Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Hello, welcome, and thank you for attending today's webinar on hospital and provider liens. My name is Michael Walrath. I am the Director of Hospital and Provider Lien Resolution for Synergy Settlement Services, and come to you today after a approximately decade and a half career litigating the reasonable value of healthcare. As you likely know, Synergy Settlement Services is your firm's best partner for all services related to post-settlement issues, starting with lien resolution and all the way through structured settlements, trust services, and even tax deferral of attorney's fees. Today's webinar will focus on that first line of Synergy services, lien resolution. And more specifically, we will be talking today again about hospital and provider liens, as opposed to all the other liens which Synergy also handles that relate in one way or another to subrogation for payers who've actually already paid healthcare bills. This particular segment on hospital and provider liens focuses on those liens that healthcare which has not been paid for. These are direct liens against the settlement proceeds held by either hospitals pursuant to statutes in the various states which have them, or by contract, either letter of protection type contracts entered into with a plaintiff and or his counsel, or contracts that hospitals use on admission that create liens against third-party recoveries. As I'm sure you've noticed, the national and local news have recently been highlighting hospital charges. We've all seen the headlines, and it's no secret, hospital and medical charges in this country are unreasonable. Some of those headlines are listed here. There are literally new headlines in every state every day. The problem is immense, but it's especially interesting when you are talking about plaintiffs who are one of the very few portions of the patient population literally asked to pay those full bill charges. Ironically, that portion of the patient population, plaintiffs who are facing hospital liens or letter of protection liens with other medical providers, are also one of the few portions of the patient population who are represented by counsel. Nonetheless, that is the interesting part here. They are asked to pay full bill charges when virtually no one else is, pursuant to these statutory and contractual liens. What I have here for you to illustrate the discounts that are available and that are often seen in this transaction are three different bills. Now, these are live actual cases with Synergy right now that are in the process of negotiation. The left column Left column shows the state that the bills are from and the full bill charges. There's two here from South Florida, $263,000, $315,000, and one from Southern California for about $645,000. Those bills are attached to the settlements in those three cases by way of statutory hospital liens. Now, the question is, how much would you pay for these bills? And I ask that question of virtually every firm that I present to across the country, and I get pretty consistent answers. I'm often told that lawyers would never settle for less than a 20% discount and feel that a 40% discount is a very good discount, a home run, a lot of them refer to it as. And I wanted to put in the right-hand column what my analysis was after using these three hospitals' self-reported cost data of the actual reasonable value. It's important to remember that reasonable value is not related in any way to the full bill charges. It's not a percentage off, it's not some average of different percentages. It is actually the cost of care calculated by using the hospital's self-reported sworn data with a reasonable profit above cost. In the first case, you see that even though the bill was $263,000, the analysis came back at less than $24,000, a savings of $240,000. Obviously, that makes the 40% off home run not quite a home run. The Southern California case, the $645,000 case, the reasonable value came out to $148,000, a savings of almost $500,000, nearly twice the savings under a 40% off model. And the last bill, as you can see, again, a $21,000 reasonable value on a $315,000 bill. I will point out that those two South Florida cases are from the very same facility. That's why the reasonable values are both so shockingly low. That facility has been determined by researchers in a recent Health Affairs article to be one of the top 50 worst overcharging facilities in the country. So that's why the consistency there between the reasonable value of these two very large hospital liens. For those of you wondering why hospital liens are so important, why healthcare liens in general are something to be very cautious about and to learn about, I wanted to talk about the three main reasons why I think this is such an important topic. Number one, 41 states and the District of Columbia have all enacted some kind of a hospital lien statute, which attaches to the settlement proceeds in the amount of reasonable charges for the most part. Almost every state statute limits hospital liens to reasonable charges. Those statutes also require the liens to be resolved prior to distribution, or at least the full amount of the alleged lien held in trust until that lien is negotiated and resolved. The liens also require, if it cannot be resolved, they require an adjudication at impasse. So if you do reach impasse with a hospital lien holder, you would have the ethical obligation and essentially the legal obligation pursuant to the statute to have that dispute adjudicated so that the third party who has a valid lien against a settlement has its day in court. Another reason that these liens have become more and more important, especially lately, is that hospitals are increasingly foregoing Medicare reimbursement and Medicaid reimbursement in favor of correctly citing the Secondary Payer Act and saying that that Medicare is secondary to the primary third-party benefits. So basically, the Secondary Payer Act, the rules interpreting it, and all of the Medicare guidance that is available on this topic all say that Medicare is second and that hospitals not only may but must comply and first bill your settlement before they submit to Medicare. The third issue that I find to be a real motivator is that negotiating these liens can sometimes make plaintiffs' lawyers feel a bit hopeless. You're put in a position of either declaring impasse, in which case you have to adjudicate the lien, or paying more than you should. A lot of that is because we so often allow hospitals to dictate the tone of the negotiations and the vocabulary used, basically forcing you to negotiate in terms of a discount as if their full bill charges were due in the first place, when legally they're not. This results quite often in, again, a declaration of impasse which forces litigation, or a payment that exceeds what you and your client want to pay. As I alluded in the previous slide, hospital liens and letter of protection liens do often carry legal and ethical exposure. Hospital liens are often statutory, and although those statutes do vary state to state, in Florida county to county, most are consistent in the sense that they have penalties for impairment of the lien. Those penalties, those impairment provisions, can shift the responsibility for paying the lien to the attorney who caused the impairment, and also give entitlement to fees and costs if the hospital were to prevail. Contractual liens, if an attorney signed a letter of protection, for example, can also create legal exposure for breach, for the damages associated with it, and again, for fees and costs. Ethical exposures, those flow from the bar ethical rules in each state, which obviously differ state to state, as well as do the ethics opinions interpreting those rules. But the common thread is that most states hold pretty tight penalties, ethical penalties, for lawyers who ignore valid health liens against their client settlements. I can say for sure here in Florida, several attorneys have been disbarred for ignoring hospital liens. Now, as I also said previously, the ethical rules and the opinions interpreting them do require lawyers to attempt to amicably resolve valid liens, or to adjudicate those liens at impasse. And I wanted to point out that although the most common vehicle for adjudicating a lien dispute is an interpleader, or I should say the most commonly understood vehicle is an interpleader, in most states that is not the only option, and I would suggest it should be the least favored option, for some reasons that I'll get into a little bit later in the presentation. Now, it's a good time to explain the very important difference between a debt and a lien. Some of you may know that difference quite simply, but the reality is it still causes a lot of confusion. Some of it is a creature of the state ethical requirements, but realistically, debts and liens are completely different things. The statutes deal with liens, not debts. And generally speaking, a valid lien must be protected in trust, but a debt does not. So if a provider is a mere creditor, in other words, if a medical bill or a hospital bill is nothing more than a debt, it's typically up to your client whether to pay that debt from the proceeds or not. While I believe that clients should pay accident-related medical debt while they have counsel and the proceeds to do so, it's up to them. That is exactly the opposite of the case, however, if there's a lien. If there's a lien, no matter what your client wants to do, your ethical responsibility is to protect it in most states. Simply put, just to make sure that we're clear on this point, because it is that critically important, liens attach to proceeds while debts attach to people. So when you're talking about liens, in most states and in most circumstances, a lien must have an underlying debt. A lien is essentially a security instrument, attaching a debt to some existing property, in this case, a settlement. But be careful, because I hear an awful lot, and I get a lot of calls and questions about hospital bills that when they are requested from the hospital in order to figure out who has liens and how much everybody owes, often contain write-offs and self-pay discounts which drastically reduce the balance. And I want everyone here to understand that relying on those self-pay discounts and write-offs is very, very dangerous. I see way more often than not, almost 10 out of 10 times, when a hospital learns of a third-party recovery, they reverse all self-pay discounts, all charitable write-offs, all those kinds of write-downs that you see on these hospital bills, and revert to their full bill charges. If they do that after you've relied on them and already dispersed, you're going to be in a very difficult position. So always, always, always be very careful of self-pay discounts and charitable write-offs. Now, if your client elects not to pay an accident-related medical debt from his or her settlement proceeds, your real only ethical obligation at that point is to make sure that they understand that the debt is still out there, that the hospital or medical provider may very well come calling, may even file a collection lawsuit against them in addition to impairing their credit. And for good measure, I would make sure they understand, and I would do so in writing, that you are not representing them if they get sued for that debt. If the client wants to instruct you to give them the money rather than pay a medical debt from the proceeds, that's fine, ethically speaking, but I would cover your bases to make sure that they cannot later on say that you did not advise them of the peril that they could be in for making that decision. In addition to the ethical and legal exposures that liens can create, both statutory and contractual, there are practical issues that also accompany these liens as far as your practice is concerned. The first and most practical of them, perhaps, is the fact that your attorney's fees are capped. The fee caps effectively make all of the hours that you invest into lien resolution a sunk cost on your file. As you know, you get paid a amount certain based on the settlement, and after the settlement, all time you spend just reduces the amount that you made if it's compared to the amount of hours that you invest. So you're limited in how much free time you have and how much free time you can invest after your settlement because of your attorney fee caps. Another practical issue for many clients, not all, but many, is that they don't want to have this debt out there. Many clients want their debt resolved. They, despite the fact that they have a limited settlement, they want you to somehow make sure that everything that happened to them in this accident is taken care of through the settlement. Because of that sometimes unreasonable expectation, reducing medical bills is often just literally required in order to fit all of the special damages into a policy limit. Even a 100 policy, if a patient has an emergency room bill and then a follow-up surgery, is going to require some pretty heavy lifting on the lien resolution side in order to still have the client sign off on a closing statement and have some money in their pocket. I think we all could agree that it's virtually impossible to get them to do so if they don't. The third practical issue regarding hospital liens and medical liens in general is that most of us, most plaintiffs' injury lawyers, simply don't have a depth of experience in litigating the reasonable value of healthcare. While we're all quite experienced in negotiating medical bills, it's the access to the data and the analysis that's needed to level the playing field with the hospital that many plaintiffs' injury attorneys lack. And that knowledge gap creates just a practical issue when you're negotiating with the person who has all the knowledge and all the data and is essentially holding all of the cards, because the lien ordinances and statutes are so often in the hospital's favor. As I mentioned, speaking of hospital liens in particular, 41 states and the District of Columbia do have lien statutes, or in Florida it's by county ordinance, some other states as well, I believe. Those statutes typically limit liens to reasonable charges. So I do recommend that all of you take a moment after the benefit of participating in this webinar to review your state statute or your county ordinance, as the case may be, and look for that language. If you have an extra minute or two, I would recommend also doing a quick Lexis or Westlaw search for that statute and just take a look at the case law that has interpreted that language in particular, the limitation to reasonable charges. Most states hold that plaintiffs, patients, do have a right to challenge the reasonableness of the charges in a hospital lien. That really is the nexus, at least for standing, to challenge these liens. And then the legal arguments are something that we'll get into in a moment. The other thing that most states do have some provision for in their lien statutes is some sort of an equitable distribution provision. Equitable distribution, as most of you know, is essentially a fair division of a limited settlement. If you don't have enough to pay everyone, what would be the fairest way to split it up? Some of the more common statutory equitable distribution provisions for hospitals limit the lien to 50% of the settlement. That's a pretty high one for the hospital. Others limit it to 50% of the net settlement, which is more akin to the third, a third, a third split that most of us are just commonly familiar with. Some states, however, do not have those provisions, and in at least one of those states, which happens to be my state, in Florida, there is case law that makes it very clear that there is no equitable distribution of hospital liens, and the hospital can take the entire settlement with nothing for the attorney fees, nothing for attorney's costs, and nothing to the plaintiff. Thankfully, most hospitals will still negotiate. However, having all the cards, they are a little less fair than they would be if there was a statutory formula, as there is in most states. So I do recommend you take a look at your state statute. That is where the requirements come from and where the legal arguments ultimately come from with regard to reasonable value. As I mentioned, the hospital lien statutes and ordinances, as the case may be, are the beginning point for at least your standing to challenge the amount of a lien, as is the common law interpreting them. But challenging the reasonable value is not necessarily limited to the lien context. Most of the arguments for challenging reasonable value come from the common law and were formed in some sort of a payer-provider dispute between a healthcare provider and a patient, perhaps and quite often completely unrelated to a personal injury case. The question becomes, how much does a patient owe a hospital when they receive a hospital bill? And a lot of people believe incorrectly that they owe the amount of the bill, and they ignore the very most important concept behind arguing against these full bill charges. That concept is the doctrine of the open price term. If you think back to the formation of this agreement, the agreement between the patient and the hospital to receive and pay for hospital services, you would notice that there's never an agreement to the price. The patient agrees, even if they sign a contract on admission, which many of them do, to pay the hospital's charges, or in some cases, even to pay the hospital charges as set out in the charge master price list, which is available upon request for review. All sorts of language that the hospitals have attempted to bake into their agreements. But one thing that they do not have within the four corners of those contracts is a price term. And when they don't have a price term, only a reasonable price is due under the common law in most states. Now, there are exceptions, and my guess is if any of you listening today live in a state where the courts have held, or the legislature has held, and then the courts have held, that the amount of a hospital bill is per se reasonable, you know it. Those of you in Arizona, I'm sure, know that fact as well or better than I do, and there are other states as well where the law is not so good. But generally speaking, a hospital contract and a hospital transaction requires reasonable charges to be imported into the open price term contract. So I'm going to go through a couple of cases just to show you a few quotes from a few different states to give you an idea of the basic arguments that I am talking about. In Florida, the seminal case on hospital billing disputes is the case of Payne v. Humana Hospital, Orange Park, a 1995 first DCA case, where the court held that a patient may not be bound by unreasonable charges in an agreement to pay charges in accordance with standard and current rates. When a contract fails to fix a price furthermore, a reasonable price is implied. Humana thus is limited to reasonable compensation. What they're talking about here and elsewhere in that particular opinion, they go into detail about the doctrine, the open price term doctrine. If you don't have a price term in the contract, you simply don't owe whatever the seller tells you you owe later. Instead, the courts must import that reasonable price term into the open price term contract. The federal case of Calamara versus Mercy goes through three factors which are very important and show up in almost every state that discusses the evidence that is relevant to reasonable value. The three factors that a patient would be able to put on evidence of in order to help the fact finder determine the reasonable value. The Calamara court stated that a plaintiff's claim of unreasonable pricing for hospital services could be proved based on the following non-exhaustive types of evidence. Number one, the relevant price for hospital services, including the rates charged by other similarly situated situated hospitals for similar services. Number two, the usual and customary rate the hospital charges and receives for the services in question. And number three, the hospital's internal cost structure. So number one, they're talking about UCR. What is the average full bill charge in the community? That would be relevant, not dispositive, but relevant to the reasonable value of the charges. The second factor is talking about the amount that the hospital is paid for their services. Now that is quite important, and you'll see that in other quotes. They're talking about average managed care rates, really. They're talking about how much do the BUCAs, the Blue Cross, United, Cigna, Aetnas of the world, pay for this hospital care. And the reason that that's relevant is because, not because this uninsured patient has access to those discounts, but because the hospital negotiated those discounts. You had two very sophisticated business entities sit down with their counsel and hammer out an agreement for millions of covered lives at these discounted rates. That is at least relevant to the reasonable value. Again, not dispositive, but at least discoverable and arguably admissible to assist the fact finder in making the decision of what the reasonable value of the hospital care would be. And the third factor, which is my favorite factor because it is the simplest to understand for a fact finder, for a lay person on a jury, is the internal cost structure. How much did it cost the hospital to render the care? To me, the simplest definition in the world, in a layperson sense, of a reasonable charge would be the cost of care plus a reasonable profit. Therefore, the cost of care is not only relevant, it's critical to determining a reasonable hospital charge. So this case is one that you'll see show up even in other states because these factors are used in many states because they make a lot of sense. The Bowden case in Georgia also talks about the amount a hospital receives as payment in full and determines that that amount is relevant to the reasonable value. The court stated that the amounts that TMC charged and agreed to accept as payment in full from other patients treated at the same hospital for the same type of care during the same general time frame that Bowden was treated may not be dispositive of whether TMC's charges for Bowden's care were reasonable under Georgia's hospital lien statute, to the extent that other patients were not similarly situated. in other economically meaningful ways. But that does not mean that how much TMC charged those other patients is entirely irrelevant, particularly in the broad discovery sense, to the reasonableness of the charges for Bowden's care. Again, it's that second factor from Calamara. It is the amount received as payment in full across the entire patient population, which is relevant to the reasonable value of hospital care. The North Cyprus Medical Center case, a somewhat recent Texas Supreme Court case, also deals with this same issue of what evidence is relevant to the reasonable value of a hospital bill. Now, I should point out that all of these cases got to this point because there's no agreement to price, as we already discussed. So the reason that all these cases are trying to determine what evidence is relevant to the reasonable value is because it has already been determined that a patient does not owe the charge master rates merely because the hospital says they do. Now, this Texas case is a perfect example of one that literally cited the Calamara case. It cited that case for the proposition, as the case that we just looked at in Georgia did, for the amounts received. In other words, the managed care rates. In fact, the majority of this case was about the managed care rates being discoverable, no matter how badly the hospital wanted to fight against that for trade secret reasons and everything else. The Supreme Court of Texas held that those rates are discoverable. They may not be dispositive of the reasonable value, but they certainly are relevant to it. But the quote that I have here is talking about the third factor, which is cost of care. And what the court said is, in any event, for discovery purposes, a hospital's costs surely have some bearing on the reasonableness of its patient charges. It cites Calamara, as I said, noting that a hospital's internal cost structure could play a role in evaluating a claim of unreasonable pricing. Accordingly, we hold that the trial court did not order the production of irrelevant information. Here, the trial court did order the hospital to produce not only the managed care rates, but also their internal documents, which evince the cost structure, which evince how much it costs the hospital to treat its patients. So, having discussed a little bit about the basis for challenging hospital lien amounts and hospital bills in general, as well as the legal arguments that circumscribe the evidence that should be discoverable and arguably admissible to prove the reasonable value of healthcare, I wanted to go through a bit of a case study to show you another actual hospital bill, but this one has been resolved, so I do know not only what the analysis was, but what the hospital ultimately accepted. The bill that I wanted to discuss was a hospital bill which did have a hospital lien associated with it in the amount of $95,457.12. Now, those full bill charges, as we discussed before, were the starting point for the negotiations before the synergy model was developed. So the PI lawyer would normally negotiate for a discount with the hospital off of that $95,000 bill. And as we discussed before, the normal range of discounts that I have been told by most of the firms that I've discussed this with are somewhere between 20 and 40% off. So I wanted to lay out what the numbers would look like at those various levels. So if you were to get a 20% discount off of this bill, you would still pay $76,365, which, having done the cost analysis, proved to be a 641% profit to the hospital. A 30% discount came out to somewhere around $67,000 and a 418% profit to the hospital. And even a 40% discount, as you'll recall, I'm often told that is the home run. That's what firms are quite happy with, would be a $57,000 payment and change, and would still yield a 344% profit to the hospital. I would like to think that most of you would agree all these profits are exorbitant. A hospital, or any business for that matter, does not need to profit 344% above its costs in order to make money. Using the hospital's self-reported cost data, I was able to analyze this $95,000 bill and determine, in accordance with the cases that we just went through, what was the cost of care to the hospital in treating this particular patient. When I did that, I then added a 50% profit above cost to be reasonable. As I said, I believe the simplest definition of a reasonable charge is the cost of care plus a reasonable profit. So I analyzed the cost of care, added a reasonable 50% profit, and estimated the reasonable value of this bill to be approximately $20,000. Now, most hospitals will not simply agree to that amount without some negotiation, but it does form a different and quite verifiable starting point for those negotiations, rather than starting at their $95,000, which nobody ever pays. So notice here, if you add 25% above that reasonable value, you're only at $25,000. That's a 74% discount if you wanted to look at it from the other end. If you add 50% above reasonable value, you're only up to $30,000 and still at an almost 70% discount. And even doubling the reasonable value, offering the hospital $40,000, is still a 58% discount, still quite better than that home run, quote unquote, 40% discount. Before proceeding, I should explain how I arrived at the cost of care that I used in the prior case study that we just went through. As I said, I estimated the reasonable value by adding a reasonable 50% profit above the cost of treating the patient. However, how did I arrive at that cost? Well, hospitals, at least every hospital who accepts Medicare, which is essentially every hospital, is required every year to submit a document called a hospital cost report to the federal government under oath as part of their Medicare compliance. Those documents include in unbelievable detail the costs incurred by every revenue center at the hospital. Every department, so to speak, has different costs, and those costs are recorded and submitted under oath to the feds annually. Those costs include everything from the anesthesia department's pro rata share of parking lot maintenance to janitorial services. It is unbelievably in depth. And one of the pieces of data that can be teased out of these reports is what we call a cost to charge ratio. In every department, if you take their total costs and divide them into their total charges, you can get a cost to charge ratio, which can then be used to determine the cost of rendering every single item that is billed out of that department. So if you take a hospital bill with the benefit of all of this data, and in our case, a paradigm that allows me to run a bill through these various cost to charge ratios for any given hospital, you can determine the cost of care for each line item on the bill, total those up, add a 50% profit, and in the case study we just went through, I arrived at approximately a $20,000 reasonable value. That analysis that I just described is available through Synergy in two different formats, in two different ways. Firstly, if you intend to negotiate your hospital liens yourself, I highly recommend, as we discussed, instead of negotiating down from the unreasonable full bill charges, that you consider a reasonableness report from Synergy, in which we would analyze the hospital bill and eliminate, first of all of the non-billable charges, and then reprice all the billable charges to the reasonable value as I just described. Once you have that report, you can then negotiate up from the cost of care rather than down from the hospital's unreasonable charges, and you only pay Synergy 10% of the additional savings you obtain using the report. In other words, 90 cents of every dollar you save using this report goes directly into your client's pocket. The other option are Synergy's full negotiation services. Basically, we use the exact same data and analysis, the only difference being that Synergy would negotiate your hospital lien for you and charge 15% of the additional savings that we obtain doing so. Either way, Synergy is never a cost to your client. We're always a savings. In other words, if we do not obtain a discount, or if you do not obtain a discount using our reasonableness report, our services are free. There's no fee whatsoever to Synergy. And that brings me back to this slide, which we looked at previously. As you can see, the deepest discounts available are discounts based on the reasonable value, not based on a 20% or a 40% discount from full bill charges. So the question becomes, why would anyone choose to overpay and do the negotiating yourself? It is quite obvious that the deepest discounts are available using reasonable value, and Synergy is always happy to assist you in either relaying that reasonable value through a reasonableness report or using our negotiation services so that you don't have to handle the negotiations at all. Stated somewhat differently, what is the path of least resistance? Remember, 100% of the post-settlement time and resources that you invest resolving hospital liens are sunk costs. And hospitals will often agree to a discount of 20% with very little resistance, even 40% with a little additional effort. So traditionally, the path of least resistance and the financial disincentive both pointed towards resolving hospital liens at a 20% to a 40% discount. Well, not anymore. Now, Synergy is the true path of least resistance. Of all of the options, Synergy requires the least amount of time and resources and delivers the absolute deepest possible discounts. I would like to thank you for joining today's webinar. I do hope that you learned something about hospital and provider lien resolution and about the services that Synergy offers in that regard. Please feel free to contact me anytime if you have any questions about what I said here today or would like to discuss any specific aspects of your ongoing hospital and provider lien negotiations. Contact Synergy at either of the numbers shown on your screen and schedule a consult today. I look forward to hearing from you. And again, thanks for joining me. Thank you all. Again, it was a pleasure presenting today, and I wanted to let you know that I did receive, it appears to be 4 questions during the course of the webinar, and I wanted to quickly answer them. Question number 1 was, is a third-party collection agent entitled to assert a statutory hospital lien on behalf of a hospital? And if so, is the hospital's internal adjustment or compromise binding on its collection agent? That's a good question. If a collection agency purchases a hospital debt in a lien state or a lien county, in most states, they cannot assert the lien. In other words, in most states and counties, depending on how the liens are codified, the hospital is the only entity who can enforce, who holds a lien, who can be a lienor. Now, if the collection agency is merely an agent of the hospital collecting on their debt, they can and routinely do enforce hospitals' liens for them, but it is that transfer of interest that would be most important. And I am happy, whomever submitted this question, if you want to reach out to me either via email or on the phone, I'm happy to discuss the specifics of your question, and maybe I can give a little better answer. The second question was, what is the cost for Synergy to negotiate a bill? Is it a flat fee, hourly, or percentage of the savings? Our fees are calculated on a reverse contingency basis, that is a percentage of the savings. We charge 15% of the additional savings we obtain, And we do cap that fee at 15% of the client's net in the case of limited settlements. So basically that just ensures that, as you can imagine, if you have a 100 policy and a $500,000 bill, you're not going to be able to pay Synergy 15% of the savings off of that bill if we get it reduced on an equitable basis down to fit within that limited settlement. So we cap our fee to make sure that we never take a disproportionate share of your client's net. The third question, what are your average results and what average turnaround time? Well, this is a very common question, but it's also a very difficult one. We do have averages, of course, but they average these numbers across a wide range of amounts and times, and on any given case, it may or may not have any relevance. But with that said, our average turnaround time is 90 days. This is looking at last year's data. Our average was 90 days, and our average discount nationally in 2019 was 61%. And that was across both hospital and provider liens, LOP liens. I think while I was answering, I got two more. One of them, is there a minimum value of gross medical bill that you need in order to accept a contingency fee on a negotiation of the bill? Yes, Synergy does have a threshold. We like the liens to exceed $5,000 and the settlement to exceed $25,000. As long as those two thresholds are met, we're happy to do either the reports or the negotiation. And two more. What about a state such as Maryland that dictates by statute hospital charges? That's a great question. Maryland is very difficult because Maryland is the last all-payer state in the country. I believe there used to be 17 or so states that use the all-payer model. The all-payer model, though it's a lot more complicated than this, is basically that the payers have all adjusted their reimbursement rates so that they all pay the same amount, and accordingly the hospital charges are also calibrated towards those reimbursement rates, and they are approved by a commission in Maryland and a couple other states. Arizona is one that I mentioned earlier, and that commission basically blesses the hospital rates. So what that means to me is that I wouldn't want to litigate the reasonable value of care in Maryland because I think you'd lose. I think that the courts ultimately would say that these rates are approved, therefore they are the reasonable amount. However, we have had good results in Maryland at a number of Maryland hospitals, including Johns Hopkins, which is sometimes referred to as the gold standard, not only in Maryland, but nationally by some folks in the world. We do still get good discounts in Maryland. However, it's much harder with big settlements in Maryland. I find the hospitals there pretty reasonable with regard to equitable distribution and hardship situations with regard to your case details, but it is tougher to get a pure reasonable value discount. We do still run the same analysis, and the same analysis does still show some savings, and we have gotten some discounts. So I encourage you, because Synergy is a risk-free proposition, to try us even on your Maryland liens, just with that caveat that they can be a little more challenging at times. Another question I've received is, does Synergy negotiate Medicare liens? And I'll just say yes, and all other lien types as well. This webinar was limited to my division, the hospital and provider lien division. However, we handle Medicare, Medicaid, FEBA, ERISA, both self-funded and not. Military liens, we across the board. Synergy is your lien resolution solution for any liens attached to your settlement. And the last question, if a particular hospital has not submitted sworn cost data to Synergy, what data does Synergy use to calculate the reasonable value of the services? First of all, the data is not submitted to us. Every hospital who accepts Medicare is required to submit their cost data to the federal government under oath. We merely access that data. We've collected and collated that data so that with our paradigm, we can take any bill from that hospital, run it against their cost data, and crunch out this estimated cost of care that I was referring to, and add up 50% profit and estimate the reasonable value by doing so. So that's how we do it for all hospitals, and pretty much all hospitals do report this data because it's a requirement if they accept Medicare, and virtually no hospital out there does not accept Medicare. But your question does lead me to a distinction that I should mention. that analysis is limited to hospitals. It does not include providers or other non-hospital facilities such as nursing homes. Those facilities and those professional providers, for example, or ambulatory surgical centers, they do not report that data, and therefore we don't have hospital cost reports. So the way we analyze those bills is different. We use several different data sets to actually approximate the three factors that we talked about from the Calamara case. We use Medicare data, actual Medicare reimbursement data, to approximate cost, because Medicare is supposed to be somewhere around 7% above cost or so. We kind of give them that 7% and just equate Medicare reimbursement to cost, and then we add a 50% profit to that. We also use UCR data to approximate the average charges in the community. That's exactly what UCR data is. And then we use workers' comp data to approximate the average managed care reimbursement. Not perfect, but average managed care reimbursement is something that's pretty widely protected by providers and harder to get. So that's sort of the best we can do, working on some other data sets that seem to be available, and we're trying to work those into our system. But with those three that I just mentioned, we take those three different analyses on a bill, we average them together to get an estimated reasonable value on the non-hospital bills. I did receive another question. Does military negotiation include VA liens? Yes, it does. We have an entire military division that handles all of those kinds of liens. So we encourage you to reach out to us, and we can connect you with the subject matter expert in that division. I got one more. Have you had success in negotiating the life flight charges? You're right, those are tough. $35,000 to $50,000, that is pretty much the range that I see on average. Yes, we handle quite a few of those, and yes, we do get those reduced quite often to somewhere between $15,000 and $20,000 on a bill of $40,000 to $50,000 or so. So yeah, we're seeing pretty good reductions there. They're very tricky because those providers, number one, are very predatory in my opinion. It's a really it's a long story, but they've really made some moves that make them very difficult to deal with, and they know it. So they have a pretty good legal protection around them, and it's hard to challenge their rates. But we have been successful. And as I said, 15 to 20 grand on a $40,000 to $50,000 bill is probably our average, though I haven't pulled the exact average. So I think we're going to wrap it up there. I think there's also some more questions coming in, but I'm going to go ahead and answer those offline. Again, I thank everybody for attending today, and I hope to hear from you if you think that Synergy can be of any assistance, either through hospital reports, which will empower you to better negotiate your own liens, or through our negotiation services, which we're always happy to offer. Thanks again. Bye-bye.